Good morning and welcome to our webinar on strengthening our response to elder abuse. My name's Karen Williams and I'm the Principal Solicitor with ADA Law, part of ADA Australia, and your facilitator for the session this morning or later when you're watching it over recording. First, I'd like to acknowledge the traditional custodians on the land on which I live and work, the lands of the Turrbal and Yagara peoples, traditional custodians of the lands and waters of the Brisbane area. I pay my deep respect to their elders, past, present, and emerging. I also acknowledge that we may have people across Queensland as part of the audience on many different lands and wish to acknowledge the many traditional owners, their elders, and any First Nations people participating today. I also want to thank Legal Aid Queensland who've sponsored this session, and it's a result of collaboration of many agencies, starting with the members of the Gold Coast Elder Response Panel, and in particular, the Office of the Public Guardian and the Elder Abuse Prevention Unit. Some of our panel members today are part of the stakeholders and other agencies who have been strong collaborators are mentioned in the portal. The webinar today is built around two complex case studies that touch on a number of key topics that have merged from a survey of Gold Coast members, and we have a range of experts to assist in understanding and highlighting the next steps that we may take for ourselves should we come across similar situations in our day-to-day work. The webinar, and we've put the key topics that people were wanting to know more about up on the screen there for you. The webinar is focused on Queensland law and provides general information and guidance only and does not constitute legal advice. But very generously and excitedly, in order to set the scene, we have Lisa Ruckmuth, who's a program administrator of the New York Elder Abuse Centre and manages day-to-day operations of multidisciplinary teams who respond to concerns raised about abuse of older people. The reason we have Lisa here is that a few years ago, ADA Australia CEO Jeff Rowe met Lisa when he was undertaking his Churchill Fellowship. And Lisa's graciously going to set the scene from New York for us today and giving us an overview of her experience and key topics related to ageism, human rights, and the elder justice framework more broadly. So I'd like to warmly welcome Lisa and give her some time to set the scene for us today. So Lisa, over to you.
Thank you so much, Karen, and good morning to everyone. Thank you so much to the entire Gold Coast Elder Abuse Response Panel, ADA Law, the people of Queensland, the ADA Event Planning Team, and Community Legal Services. Thank you to Jeff Rowe for introducing me to the incredible work that is occurring in Australia regarding elder abuse and elder justice. Thank you, Karen Williams, for working with me to bring information about our work at NICEAC, Weill Cornell Medicine. I'm honored to be here today to participate in this important conversation. I oversee the New York City Elder Abuse Center at Weill Cornell Medicine. Our program is part of the Division of Geriatrics and Palliative Medicine. We provide services to professionals who directly serve older adults and concerned persons who are in the lives of older adults. We facilitate enhanced multidisciplinary teams in the 5 counties of New York and provide technical assistance to enhance multidisciplinary teams in New York State. We also oversee technical assistance that is provided to 23 federally funded teams across the United States. The Office of Victims of Crime, a federal department, is committed to funding 10 new teams each year across the country in the United States, with technical assistance support provided by our teams. We also run a New York statewide helpline for concerned persons in the lives of older adults. The concerned persons can be anywhere in the world, while the older adults that they are concerned about must live in New York State. Our program is also involved in multiple projects aimed to decrease elder abuse and enhance elder justice. A couple of these projects include working with the New York City Department for the Aging and the New York City Department of Education to create a curriculum or module on ageism and elder abuse to be taught to children in elementary schools across New York City. Another project is aimed at training professionals on using a tool to identify quickly when an older adult needs a capacity assessment. This tool was originally developed by many who were part of the development of the New York City Elder Abuse Center, NYSEAC. Another project involves us assisting with research to learn more about re-victimization of older adults. We are also actively the creation of laws or the non-creation of laws, and that's for another day, around elder abuse in New York State. Our team members are actively involved in coalitions and work groups that address many different issues related to elder justice locally and nationally. The work that we do at the New York City Elder Abuse Center is extremely collaborative and relies on the strong partnership of other elder justice programs and leaders. This collaboration also includes sharing the limited resources and funding for elder abuse programs across New York City and New York State and the country. NYSEAC grew from a very small group of 2 in 2009 to a team of 18 currently. The slow and planned growth was key to making an impact on elder justice in New York City, New York State, and across the country. I'd like to briefly talk about a couple of areas that you expressed an interest in learning more about. NYSEAC has used the enhanced multidisciplinary team approach to talk about elder abuse. As we all know, the issues are complex and require different professionals from multiple disciplines with open eyes and ears to collaborate and utilize creative ways of approaching systemic ageism. Ageism is at the crux of elder abuse, and combating ageism is one of the ways we can begin to dismantle elder abuse and truly put elder justice at the forefront of our work. Ageism impacts and is embedded in all areas that you identified as your need to learn more about. Ageism looks different in different cultures. Where do we begin? We need to begin by layering our perspective. For example, every time you think about balancing the idea of risk with autonomy, consider the impact that ageism, consider the impact your professional boundaries, and the declining health, both mentally and physically, of the older adult, and also consider the landscape under which you are providing services. At all times, also consider the impact of one's trauma, both historic and current, on the plans that you create to serve the older adult. A well-designed and cultivated enhanced multidisciplinary team can greatly help with this process. Engaging the older adult in decision-making, even when it involves the older adult remaining involved with the alleged abuser, can be difficult and potentially contrary to many of the pillars of our different professions. Balancing risk with an older adult's autonomy is paramount in setting the framework for installing and maintaining an individual's human rights. The work needs to be structured around the older adult's culture, with an awareness of the impact of the role historic oppression may have played in the older adult's life. Keeping in mind with historic oppression, a level of mistrust of systems occurs for individuals and impacts each person in unique and potentially devastating ways. Supported decision-making requires working in partnership with older adults as opposed to serving the older adult in a pre-prescribed way. Human rights and right to agency is partially wrapped up in intersectionality, and there is a need for equity and inclusion. This is paramount in the work. There are many competing issues when we talk about elder abuse and elder justice. Understanding the different levels of elder justice and the experience of the older adult is paramount from the beginning of your professional relationship with that older adult. Building rapport and partnering with other professionals is one way to begin to address the older adult as a whole person with many facets to their life. Seeing the older adult as a whole person and not just about the abuse is necessary in serving older adults. Accessing validity and being willing to be flexible and pivot or change based on the science, collaborating with scientists, working with practitioners with an eagerness to understand the root of the issue as opposed to fixing the problem is needed. Understanding the source of the trauma that an older adult may experience, then holistically working to create change is at the heart of helping to eradicate elder abuse and champion elder justice. Recidivism in abuse situations often occurs. Resilience needs to be a focal point that is embraced early on in the professional relationship with the older adult. Creating programming that focuses on resilience is not easy and requires professionals of different disciplines. This requires the service providers to be able to engage using trauma-informed care with motivational interviewing layered into restorative justice. Doctors, nurses, lawyers, social workers, case managers, housing specialists, forensic accountants, police, judges, city officials, and community-based organizations need to partner to help the older adult move to and maintain an abuse-free life. This is one strong approach to long-term change for the older adult and the elder justice system. Centering the work on the individuals and engaging with causality rather than focusing on remedial interventions. Crisis intervention needs to run and work parallel to looking at an individual's trauma history. Learning how to engage the older adult based on culturally nuanced work and the wishes of the older adult, particularly if they want to continue to be engaged with the alleged abusers. And this requires practice and training. All of this means looking more closely at your penal systems and looking to utilize a client-centered model to impact life-sustaining changes. As a practitioner, if you think about cognitive capacity as all or nothing, it's easy to remove someone's ability to make decisions. Support around decision-making and delivering service plans with this in mind lend to enhancing an older adult's agency. Information sharing about the older adult and their situations needs to occur in a respectful and confidential way. The EMDTs in New York are built to work on the multifaceted issues of elder abuse with a lens to intersectionality and a focus on person-centered work. Different disciplines approach the work in different ways. The first step to building a system relies on understanding and learning about the professionals that you invite to sit at the table and deliberately participating in the conversation. Changing the mandate of professional disciplines is not easy, but by first acknowledging what we can and cannot do in different professional realms creates trust and an ability to balance your teams so that they can be open, honest, and have open, honest conversations about how best to help older adults dealing with elder abuse in the immediate and in the long term. Thank you very much. I turn it back over to you, Karen.
Thank you, Lisa, and I understand your constraints, and thank you so much for participating and starting the webinar off for us in such a rich presentation and addressing all the themes. Okay, next I'd like to introduce the panel, and then we'll have some case studies that the panel will be addressing their questions to. So this morning, to discuss the case studies that I'll move to shortly, we have Rebecca Leong, Principal Lawyer of the Human Rights Commission, Lisa Pritchard, the Queensland Deputy Public Guardian, Dr. John Chesterman, the Queensland Public Advocate, Dr. Mohammed Khatib, who's a consultant physician and geriatrician, Nick Sellers, Senior Sergeant of Queensland Police Service, and Mary Humphreys, QCAT Coordinator, Metro North Hospital and Health Service. So we have quite an experienced panel to continue these rich discussions this morning. So the next point of the webinar is to look at the case studies. So we'll put the case studies up now, and we have our panel there. Okay, the case study A, we have Carmelita, who's a 78-year-old Filipino woman married to Frank and in her second marriage. She has adult children and extended family in the Philippines. Her home's a multi-level townhouse, which was property from her previous marriage. Um, in the last 12 months, she's lost her mother and brother in the Philippines and reports being deeply depressed as a result. Her inability to return to the Philippines during COVID times added to these feelings. Family members overseas have asked Carmelita to contribute to the funeral costs. Carmelita suffers from also severe knee arthritis and awaits surgery. Mobility and significant pain restrict her movement and attending to shopping and everyday tasks. Carmelita has been prescribed pain medication for this. And she has some plans about how she's going to manage her life going forward. She wants to convert the lower level of her home to a bed set and receive some home care. And then, oops, lost them. And she's waiting for an ACAT assessment in relation to that. Um, Frank, her husband, is a hoarder and she's unable to move around her home safely. And he's not cooperating in making the house accessible for Carmelita. Um, he's also not being helpful in allowing her to access her pain medication. During a period of severe depression, Carmelita was admitted to hospital and a diagnosis of dementia was made. Her husband Frank applied to QCAT and became her administrator for financial matters, and he was convincing the staff that he would provide assistance for ACAT um, on discharge, but he didn't get around to it. Um, his actions became more hostile and changed the lock, so Carmelita couldn't return, but she did have some friends who enabled her to stay at home with them and stay in lounge rooms, etc. So she'd had supportive friends who've assisted her to obtain a positive capacity assessment, contacting Centrelink about rearranging her pension, and reaching out to community agencies for assistance. That's the second half of the case study there. Um, one of the above agencies approached um, the local elder abuse response panel to explore further support and police engagement for Carmelita in a de-identified way, and later through the course of that study, just pop up the information sharing protocols that may or may not be helpful in reference to Lisa's talk about elder justice frameworks, and sometimes they don't necessarily extend to the full circumstances that people are experiencing. Okay, so with having just gone through the case study, and we're just going to have an audience question here to keep us on our toes. Just if you had to choose one topic only, which do you consider the main theme of that case study? Um, and there's no right or wrong answers. Just thinking about what are the themes. We have A, human rights; B, supported decision making; C, ageism; and D, capacity. So there's a live poll response that you're able to respond to that. And also, there's for the audience, there's opportunity to ask questions through the course of the case study, and at the end of the discussion of case study one, the most voted top two questions, hopefully we'll get a chance to ask those of the panel. So the first set of questions I'd like to throw open to Rebecca. So from a human rights perspective, Rebecca, what's going well and not so well for Carmelita?
Thanks, Karen, and thanks for having me here today. So when I looked at this case study, well, first of all, I should start with, we've got this Queensland Human Rights Act, which commenced operation on the 1st of January 2020. So we've had 2.5 years now of its operation, and this Act protects particular rights that have been picked out of international law to protect in Queensland. The right that stood out to me in Carmelita's case most to me is the right to privacy. That might sound surprising. If you think about the right to privacy, it just sounds like confidential information privacy. But it actually, if you look at the right itself, it talks about a person has the right not to have their privacy, family, home, or correspondence unlawfully or arbitrarily interfered with. And so home is clearly being interfered with here. Carmelita's unable to make changes to her home. She's unable to move about her own home, and ultimately she's refused entry into her own home. So that right, I think, is clearly is clearly relevant in this case. Possibly more critical though is the right to privacy also extends to protecting personal and social individuality and identity, and it includes protecting social relationships and psychological integrity. And so if you think about her right to make her own decisions, especially around in relation to her financial decisions, has been impacted, her right to private life has also been, and her right to self-determination has also been affected. There's also right to equality issues here. One of the poll questions was about ageism. So if ageism plays a factor, her rights to equality have been affected. And also the fact that her right to make her own decisions has been removed from her. She's now on unequal footing with other members of the community now. So that's also a limitation of her rights to equality. The freedom of movement protects the right to choose where you live. So that right of hers is being affected as well. Her right to property, she owns that family home. Potentially, it's arguable that she's been constructively deprived of the enjoyment of her property. She's not allowed to return home. And also the comments about her not being able to travel back home because of the COVID situation, that's limited her rights to family. So rights to family is protected under the right to privacy that we've already talked about. It's also protected under a standalone right to privacy, which protects families as a fundamental group unit of society. So the state has an obligation to protect that. There's also questions regarding, Frank is also her family, and how has that right been limited or protected in this case? And how does that play out in this scenario? And then the final right that I just wanted to talk about is torture, inhuman and degrading treatment. And I just picked up on that right because of the indication that when she's home alone, she's unsupported and she doesn't have control of her pain medication, leaving her in pain. So potentially there's inhuman and degrading treatment in this case, or alternatively, if there's a case to say that she's lost her liberty, then possibly inhumane treatment when deprived of liberty can also be engaged in this case. So that's all the rights that I identify. I just wanted to quickly mention that under the Human Rights Act in Queensland, not everyone owes duties of human rights under the Human Rights Act. So it's only going to be public entities, and maybe we'll have an opportunity to expand on that later. And the other issue I just wanted to quickly say is that not all rights limitations are a breach of human rights. So limitations, if they are justified, are still compatible with rights. So that's all I wanted to say on that.
Excellent. Thank you, Rebecca, for such a fantastically comprehensive response. Moving through the set of questions that we have and touching on various topics, John, for other agencies working with Carmelita, how can friends as supporters be recognised with a sort of formal decision maker in place that adds some complexity, perhaps?
Thanks, Karen, and thanks for having me here today. I like what Rebecca's just said. One of the things that Carmelita's friends can do, of course, is seek to have Frances removed as financial administrator. It would seem there's now evidence to support that kind of application being made to the Queensland Civil and Administrative Tribunal to achieve that. It's important to note also, even if Frances does stay in place as administrator for the time being, this only gives him decision-making power in relation to finances and nothing else. But let's imagine, even with Frances staying in place as the administrator for Carmelita, friends and supporters of Carmelita's could assist her to go back into her house and to arrange for that ACAT assessment. If Frances objects, which seems likely given his past behaviour, police assistance might be required, and I'll defer to Nick on this matter, from whom we'll be hearing shortly. Of course, we'd all prefer Carmelita's situation to be improved without the appointment of a guardian, if that's possible, but that is one option that, again, we might hear about in a moment. Point to note, though, just from my perspective, is Frances is acting outside of any legal authority, and indeed illegally, in refusing to allow her to access her own home. And hopefully with support, Carmelita's situation could be ameliorated and her wishes respected and implemented.
Thanks, John. And also, in moving through those steps that you outlined, there might be a time where people might wonder, of her friends influencing her, overly influencing her perhaps, or providing supported decision making. Is there any tips about how to determine?
Sure, yeah, that can be a very fine line, and it's a very important human rights topic, supported decision making, one of the key human rights topics for people with impaired decision making ability. And when you do support someone to make a decision, are you influencing them? One of the classic examples of the distinction but the blurred line here is you can offer someone a banana or an apple. You're supporting them to exercise choice, but you're also influencing them to eat a piece of fruit. So that line can be blurred. The key for any agency working with Carmelita is to routinely check in with her. Is this what you want? And you might ask her to talk more about her response to that question. If she was simply to say yes, you might ask her to talk about why. Just get her to articulate it a bit so that you are convinced that she's not just saying yes to please you. This is actually her view. It's very important that we meet Carmelita's will and preferences, which is a modern human rights way of ensuring that we accord to her the right to determine what she wants for herself in her life.
Thank you, John. That's a really important distinction, a really practical measure there that we can take. Dr. Khatib, there's a lot here, that you'll be able to assist us with. So there's a series of questions I'd like to ask you. So for the layperson, what are the difficulties in understanding and how to make a diagnosis of dementia when an older person may be depressed?
Yeah, thank you, Karen, and word of thanks to ADA and my very enlightened panel and audience to be a part of this very useful discussion. To answer your question, the difficulties in teasing out depression from dementia, otherwise, there are many difficulties. There are many levels of difficulties. In fact, it's a diagnostic challenge. And poor Carmelita has the whole package in terms of the medical comorbidities, the pain, her age, the social circumstances she's in, a recent bereavement, a lot of rights that Rebecca mentioned she has lost, and physical loss, environmental loss, and so on. So she is in a very fragile state. And that makes the diagnosis of depression and dementia even the more difficult. But as you said, for the layperson, or I'm sure most of these are much above that level, but the diagnosis of depression is important. It's a serious disorder. And about 1 in 5 over the age of 65 do have major depressive disorder sometime in their lifetime. And the triggers can precipitate that, prolong that, and so on. Also, a fact that we know is that about 30% of people with dementia can have underlying depression or concomitant depression at any time during their journey through dementia. That's a significant contribution. These are two different disorders. One's a cognitive functional disorder, other one is a mood psychological disorder, though there are many areas of overlap which confront the picture. So this question is important, and it's really worthwhile trying to make that distinction. Now, some of the features, social withdrawal, apathy, lack of sleep, and so on, are common to both. But if Grief led to depression. She, as you said in this case, Kamalita's case, as I was studying, she was admitted for a major depressive episode. So let's assume she had depression. And during that, a diagnosis of dementia was made, as I understand. And somewhere along that, her capacity was taken away, hence Frank was appointed as the administrator, and then led to a number of isolating factors. The DSM-5, which is the Diagnostic and Statistical Manual that we use in psychiatric and neurological disorders, Lisa from New York will be very familiar with it, but all over the world we follow it, has now said that you really shouldn't, I mean, this is shouldn't within the guidelines, diagnose dementia or a cognitive disorder within an episode of major depressive disorder. Now, that may be a first episode or it may be a recurrent episode, but within that, it is so difficult that the guidelines say that you shouldn't. But it's not just a limit of 2 months. You may actually have to wait for 6 months before you can start doing cognitive testing and thinking about it as primarily a dementing disorder. And the DSM-5 now recommends that waiting 18 months might be too long, 2 months too short, and 6 months about right to start thinking about another condition.
Hmm.
Now, yeah, I think that's, and there are, you know, to go on, there are a number of scales that we use in depression to identify depression from dementia.
That's all very helpful to understand, and that dilemma that medical colleagues face in trying to tease out the differences there. So, what steps could have been taken when there were emerging signs of depression from the grief? Is there anything, supporters or her local GP, or what steps could have been taken? At,
Absolutely. Again, the steps are many, but not well known because they get bypassed, and as these disorders which I mentioned have overlap. But certainly identifying grief, the factors that led to it. Remember, grief is different in different cultures, different environment. Circumstances of grief may be different. More than one loss, in this case, she lost two within 12 months, compounds the grief. So there may be a major grief reaction, which we call prolonged grief reaction, which is different from a mental health disorder, but can lead to it. So it can spill into a diagnosis of depression. What our GP colleagues or healthcare workers might do is, of course, first establish the facts, what type of grief, what are the cultural implications on this particular person. In this case, there's a financial burden. She may have to support the funeral. She is distant. There may be some guilt in not seeing them. So all of those, if you get the facts right, perhaps from a reliable informant, then you can work on those. And you can employ a number of agencies or incorporate a number of agencies, social workers, support groups, other assessors who can go and find out if the other medical conditions are being monitored. Their blood pressure may go out of control, they may lose compliance. They may resort to substance abuse, alcohol overuse, opioids. So prior to the diagnosis, a number of these factors can be looked into and addressed.
Thank you, Doctor. And then lastly, um, there's obviously been an assessment made that led to the appointment of a husband as a financial administrator. Is this a situation that you think it's recommended that, repeat capacity assessment should occur, and how far apart is it best that Carmelita may be reassessed if that's your recommendation?
Yes, most certainly. The ground is open for reassessment because there were a number of things. There was grief reaction, there was depression, which was major. She might have been on medications to control those. There could have been a sedative effect. She might have gone on dementia treatment. The impact of all of these on her state of mind, and during that, the assessment of the capacity. And as we all know, capacity is a dynamic process. It can change. And given all of these happen in quick succession, I would suggest after the settling of depression, which can be clinically monitored, a clinician or social workers, allied health nurse practitioners can monitor and then restage a capacity assessment, perhaps look at the depression, tailoring of medications, and if dementia is emerging, then think of specific dementia treatment. But I would certainly not lose her to follow up. And GPs are very good at doing that. They would follow her up and then engage a psychogeriatrician or a geriatrician or a neurologist, as they do in USA, to actually assess her rights in a state of affairs. And then, as you know, losing capacity is perhaps one of the biggest losses that a human being can encounter, the inability to make decisions. So I would certainly say a year time. There's no hard and fast. Depends
Mhm.
on when they're coming out of it.
Excellent. Well, that's some good, practical, useful information for our colleagues listening today. Mary Humphries, I'd like to bring you in your observation so far of what you've seen with Carmelita. Do you think ageism might have interfered with some of the system and health system responses to Carmelita?
So good morning. Thank you for inviting me. I think it's pretty obvious from where I'm sitting that ageism has an enormous impact in this case, because when you look at what has happened to Carmelita to get to the situation of having having her husband appointed as her administrator through QCAT, based on the circumstances of getting there, that timeline, if she had have been 58 or 48, I'm sure that there would have been a lot more attention paid to her depression rather than the fact that she had dementia. And I think when you work in the health system, as I do, the unconscious biases that you bring to your work, as much as you might like to check yourself, when you see an older person in a bed with their normal environment removed from them, they immediately look a lot less powerful than they would in their normal life. And all of those factors then, I think create that issue for older people in a system that I think regards getting older as a condition that needs to be treated rather than a normal part of aging.
Thank you, Mary. And then practically, and thanks for that overview, there were some things that weren't followed up after her discharge from hospital, and I'm just wondering how the health system may best sort of, and there are obviously key things that impacted on Carmelita, ACAT,
Yeah.
and also Dr. Khatib talked about possible GP follow-up for some of these factors. How can follow-up be initiated and overseen?
Well, I guess that starts with good discharge planning. And I guess it's, given the situation where a husband has put his hand up to say, I'm the carer, has probably made it an easy pathway. Oh, well, we've got someone who will be, keeping eyes on this situation. When in fact, a good discharge plan should include other agencies to ensure, like Carmelita has, not only is she got dementia, so they say, but she also has mobility issues. But I guess one of the things that I think I'd like to go back a step further, I'm assuming that the QCAT happened from the hospital while she was a hospital patient. And that in itself is a bit of a curiosity, because when someone is in a hospital patient, unless they're in a very critical situation after a critical event and need some sort of immediate decision, in most cases, the reason to go to QCAT is because there is a barrier, there's a need for a decision, and that because the person, can't be discharged without that decision being made. They can't make the decision and someone needs to be appointed to make that decision. And so in this case, Carmelita was going home. So I think from the whole situation probably was on the wrong trajectory right from the beginning.
Thanks very much, Mary. And now I'd like to bring in Lisa Pritchard from Public Guardian. What issues, some of the issues that raised right from the start here, involve quite potential legal matters, and what might be some of the barriers for Carmelita what issues might there be for her seeking legal help, do you think, Lisa?
Yeah, thanks, Karen. Good morning, everybody, and morning to all the other presenters. We've got some excellent information coming through so far. I think for Carmelita, the case study information we have is that she now has an independent capacity assessment. And of course, we work on the basis of a presumption of capacity too. So given we have an indication that Carmelita actually has capacity to make her own decisions, this probably wouldn't be a circumstance where the public guardian would be appointed for Carmelita. It certainly shouldn't be if she's shown to have capacity. The legal issues for Carmelita will be issues of a personal nature that really relate to her domestic and family violence situation and her family law situation around property and financial matters, and would also need to give some consideration to having the appointment of Frances as an administrator reviewed, given that she has the independent capacity assessment. I think some of the barriers and issues that she's likely to face from this scenario are access to legal representation. We know she's on a pension, and being able to fund a private legal representative to assist her and to provide her with some legal representation with regard to her many legal issues. Having a financial asset in her name may preclude her from legal aid funding. We've also got the situation where she may have some resources available. Frank's her financial administrator at the moment, and this would create a barrier in obtaining legal aid. And we also may, of course, see Frank not agreeing to expend finances to support Carmelita because it wouldn't necessarily be in his interests. He'll need to provide financial information to support any application to legal aid. So we've got a barrier potentially there, of course. And there are limitations on community legal centres in providing legal representation through the course of ongoing proceedings as compared to just a one-off advice session. We've also got the potential barrier with police, and of course Nick will probably talk some more about this shortly, but the potential barrier with police to commencing family and domestic violence proceedings due to a perception that she has limited ability to give evidence arising out of the appointment of the administrator, and of course the diagnosis of dementia and depression. And finally, in terms of seeking a review of Frances's appointment, there are some potential delays in seeking a declaration of capacity from QCAT.
Thanks, Lisa. And you mentioned, the presumption of capacity, which is very important, and the fact that there's been no finding of a lack of capacity for personal matters, but also the difficulty of perception, what an order can make on people around her who she might go to for help. And on the face of it, it's unlikely that a public guardian should or would be appointed. But if appointed for legal matters, and you outlined a lot of the steps that you might take, the public guardian might take if that was the case. Are there any extra steps apart from all those wonderful pointers that you outlined that you would take?
Well, if OPG or a public guardian, if the public guardian was appointed in matters, it would be an appointment not relating to property or finance. That's not within public guardian's remit, of course. And that would be based on the assumption that capacity was rebutted for Carmelita. So if there was an appointment made, the guardian for legal matters would consider appropriate legal avenues that would support Carmelita's needs. And in this circumstance would most likely be consideration of application for a protection order on domestic and family violence. The first thing that we would do would be to engage with Carmelita. We'd explain our role as a guardian for legal matters and ascertain her views and wishes around a potential application and explain what this might entail. On the assumption that Carmelita would be supportive of this and in accordance with our supported decision-making framework, we'd initially liaise with Carmelita's support network, assist her to speak with police and for police to consider commencing DV proceedings, and that might include an ouster order for Frances, and that would be on Carmelita's behalf. The guardian for legal matters might also advocate for Carmelita and speak with police directly around the appropriateness of the process on behalf of Carmelita. And there are obviously specialist teams vulnerable persons unit or high risk DV teams who are well versed in these scenarios. And we work quite regularly and collaboratively at OPG with those teams. If for any reason that this was unsuccessful, OPG could apply for legal aid funding for an independent legal representation for Carmelita, and we would make submissions as to why a financial means test shouldn't be applied in order to get some legal advice with regard to her options in commencing a DV application. And with regard to any family law proceedings, we actually have no authority in relation to any property or financial decisions. So our role in family law proceedings would relate to it would be more around liaising with an appropriately appointed financial administrator. So we would try to work with a financial administrator, which of course in this case is Francis. So we'd be trying to support, an application for his removal if that's appropriate.
Excellent. Thanks, Lisa. And you mentioned domestic and family violence framework, and we'll just put up some of the information sharing piece of the legislation that's relevant from the Domestic and Family Violence Protection Act of Queensland. And once again, we're talking about Queensland legislation and systems here. So the key principles about to firstly seek consent, or the consent principle as I've outlined just for shorthand for referrals or disclosing personal information. Safety of person takes precedence over the consent principle, and consider any adverse impact on personal safety before sharing the information. So it's important to consider who can give and receive information without consent, and the prescribed entity or specialist domestic and family violence provider that Lisa's just referred to. So it includes relevant to this circumstance police, ambulance, court services, public health services can communicate to each other in circumstances of actual or feared domestic and family violence. Support services, of which ADA would be one, non-specialist domestic and family violence, legal community counselling services may provide information to prescribed entities such as police or ambulance, health, etc., and not able to receive information or pass on information between support services. So that's the framework. Now I'll bring Nick in. So generally, what's concerned you about Carmelita's situation, the scenario so far?
Yeah, good morning, Karen, and likewise, thank you very much for the opportunity to attend. From a policing perspective, and as other panelists have stated, the situation with Carmelita is very concerning to us. It would certainly trigger a police investigation. That investigation would be conducted under the direction of Section 100 of the Domestic Family Violence and Protection Act. That section is quite unique in Queensland because that legislates that police must investigate the violence on Carmelita. There's a clear suggestion of coercive control by Frank, and that is an area that the Queensland Police has commenced training every officer in with a compulsory training package last year. And I also note that Lisa, the speaker, noted about a victim-centric approach, and that's certainly something that the QPS espouses, that we conduct victim-centric trauma-informed approach investigations generally to ensure that the lens focuses on the whole situation rather than on separate incident-based police attendances. So there is certainly enough information there that we could launch a police investigation into Carmelita's situation.
Thanks, Nick. And if you've received a referral from a panel, such as the Gold Coast where this webinar is from, or from, I understand, and where other great panels up further north, Sunshine Coast and north, what would the actual help look like from the police?
So initially, the police that would attend and speak to Carmelita and, as necessary, her support persons, as the case may be, would look to apply for a protection order under the provisions of the Domestic and Family Violence Protection Act. That protection order can contain conditions, mandatory conditions such as being of good behaviour, and as I think Lisa from the Public Guardian suggested, we could also consider applying for an oust order to get Frank out of the house, removed forcibly if necessary. That or magistrate, but also a senior sergeant of police can issue an urgent ouster order at the time whilst the police are at the scene. If it's deemed serious enough, there's checks and balances, obviously, for that process to take place. There is scope there for an investigation by detectives of providing the necessities of life, which is a criminal code offence, that it would appear there's certainly some evidence to suggest that perhaps Carmelita wasn't receiving the best care that she could have by Frank. That investigation by detectives. We also have a network of vulnerable persons units, which has been mentioned throughout the state, and high-risk teams that can assist police, general duties police, with these types of quite involved, protracted investigations. So there is a lot that police can do. We do have the issue of perhaps capacity, dealing with Carmelita's capacity. However, with that type of assistance by detectives and other trained officers throughout the state, I would consider that an order would be sought by the police. And I'll just note that when we refer to any incident, that every police officer has the ability to refer victims, relatives and friends, offenders and other people to a referrals agencies database that we have, which currently has over 500 partners in that database, and over 50 of those partners provide support older persons specifically.
Excellent. Thank you so much for that, taking us through all those steps, Nick. So before we start the next case study, we might hold questions over to the end to make sure we get through, but I just want to report on the polling question that 39% of the audience thought human rights were the key theme, 35% supported decision making, 2% ageism, and 24% about capacity. So there's a sort of a basically almost a three-way tie there. So let's keep moving because we've got a second case study to take us through to the end of the webinar. So just go to case study B, okay, which concerns Beverly, a 69-year-old woman, two-bedroom Brisbane home which she's lived since divorce 15 years ago, two adult children, Diane and Simon. Diane's in Brisbane and Simon's in Cairns. Diane has lost her job due to the economic downturn, and she's moved in with Beverly, claiming that she would provide care for her. A few weeks later, Diane pressured Beverly to accept her as a formal carer for Centrelink purposes. Beverly was cooking the meals, and Diane used Bev's money to pay for the groceries and utilities. Beverly has a level 2 home care package, so there's aged care services involved here. The service provider assists Beverly with cleaning, medication assistance, yard and transport support. No formal decision-making arrangements are in place. Service provider noticed that Diane was sometimes slapping and shouting Beverly, and she did not want to make a complaint to the police. And Beverly said to the service provider she didn't want Diane in the house, but she didn't feel she could ask her to leave. Beverly also told service providers she wanted more help, and she found it difficult to understand the systems involved, such as Centrelink and My Aged Care. Okay, so the second side of the case study, the next slide. Right. Diane realised that she was struggling with memory problems and sometimes got confused. However, when Diane wanted to sign an enduring power of attorney document, she refused that, and because she essentially didn't trust Diane would include her in decisions or consider her wishes. And the abuse that the service provider witnessed led the service provider to make a referral to the Elder Abuse Prevention Unit and contact Beverly's son Simon to make him aware of their concerns. And Simon worked with the service provider to organise emergency respite for Beverly, thinking this would give her a chance to recover and assess her situation. She went to respite. She was placed in secure dementia unit due to a shortage of beds. Her verbal and physical agitation with staff and other residents led the new GP in the facility to prescribe risperidone without her consent. Simon responded, took his mother out to her ex-husband's home several hours away from her usual residence. And then a week later, Simon returned to Cairns. Beverly called Diane to pick her up from her ex-husband's house. And Beverly then makes a call to EAPU, the Elder Abuse Prevention Unit, and tell them that Diane's providing pressure for her to go into aged care and leave her alone in the house. Okay, so we have another poll for here for the audience, and once again, forcing you to choose one topic only. What do you consider the key theme? Undue influence, sense of agency or empowerment, capacity and consent, or human rights? So I'll leave that poll open. And then I'll go to John Chesterman for some questions. And we're going to touch on undue influence here because it was a topic identified, people wanted to know more about, but also in this, from the case study and from Beverly's perspective, at what points do you think she may have experienced undue influence, and how might we be able to respond when we're witnessing this?
Thanks, Karen. I hope you can hear me. I did drop out before, but I'm back. I think Beverly has experienced undue influence incessantly. She's been slapped by her daughter, Diane, whom she doesn't trust, and has been coerced, it would appear, to nominate her, Diane, as her Centrelink carer. She didn't want her daughter and grandson in the house, but felt unable to ask them to leave, presumably because of the likely verbal and or physical response. Beverly's also subsequently been moved out of respite by her son Simon and taken to her ex-husband's house, again presumably against her will, demonstrated by the fact that she'd prefer to be with her daughter than with him. So what are some possible responses here? I think to the slapping, direct confrontation, if this is witnessed, and advise, if a service provider or someone witnessed this, advise I'm duty bound to report this and ask Beverly if she's all right and possibly report this to police. On the nomination of her daughter as carer, again ask Beverly, the advice to a service provider, ask Beverly away from Diane if this is what she actually wants, and if it's not, then suggest to Beverly speak with an advocacy agency to help her change this appointment if that's what she would like to do. And as regards Beverly's inability to ask her daughter Diane and grandson to leave, again, the important thing to do for a service provider is to speak with Beverly away from Diane and ask her, is this what she wants? If she wants them to leave, then the suggestion would be that Beverly speak with an advocacy agency to help her ask them to move out. And this needs to be communicated clearly to Diane, and an advocacy agency may be able to help her to do this. Of course, we could go further down the track towards guardianship, but my response is hoping that we can achieve these outcomes without doing that.
Thanks. Thanks, John. The second set of questions is to Lisa, responding to Beverly's situation. Can you comment on whether a complaint to OPG investigations can be made against the daughter when an enduring power of attorney has not been made, Beverly's capacity not assessed?
Yeah, thanks, Karen. Yeah, look, OPG's jurisdiction to undertake investigations is limited to investigating allegations of abuse, neglect, and exploitation of adults with impaired decision-making capacity, or investigating whether an adult has inappropriate or inadequate decision-making in place. So it's a protective jurisdiction, and any decisions or actions taken in the interest of protecting an adult must be taken in the least restrictive way. Excuse me. I had a sneeze before we started, so now I'm struggling a bit. In this scenario, a request for investigation could be made. Our first consideration would be to establish a jurisdiction to investigate. So we'd be looking at whether there's a reasonable suspicion that Beverly has impaired decision-making capacity. So we wouldn't expect or require a medical report at the point of submitting a request, but a variety of information could be gathered, including information to establish whether there's a sufficient suspicion, a reasonable suspicion of impaired capacity. And that information could include information about a diagnosis, but of course the diagnosis isn't sufficient information of itself. There might be medical reports available already. There may be observations that people have made around levels of confusion, memory loss, Beverly's inability to articulate her views and wishes. All of those things would be taken into account in weighing up whether there's a sufficient suspicion of impaired capacity for us to proceed with an investigation. But we'd certainly weigh all of that information up. We'd also be considering, of course, capacity, including being capable of freely and voluntarily making decisions about a matter. And John, of course, has already talked about undue influence. The current situation suggests that Beverly may be subject to undue influence of Diane. The service provider and Beverly's son would likely be called upon to obtain additional collateral in this regard. They're people who've got the direct observations of interactions and will be able to help us with that information. Once investigators are satisfied the threshold has been met, an investigation would move ahead. We'd make some more formal requests around capacity. There might be a health professional's report, and we'll take some more formal information from witnesses who can help us with their observations. If information is received to suggest that Beverly does actually have capacity, the investigation would cease, and we'd then be looking at making referrals and providing information about alternative pathways to whoever makes the complaint to us, so that we can get some alternative protections in place for her. But primarily, and going back to your question, Karen, because our jurisdiction includes investigating whether an adult has inappropriate or inadequate decision-making, the OPG can investigate concerns where there are formal decision-makers in place, informal decision-makers, or no decision-makers at all.
Excellent. Thanks for all that clarification, Lisa. And before making a step of making a complaint to your office, are there any other steps that supporters or family or service providers might be able to take before that, or as well as a formal complaint?
Yeah, prior to making a complaint, we would encourage the supporters and professionals to be pulling together any information that they can about that would indicate one way or another about Beverly's capacity. So that could be their most recent observations about her behaviours and her interactions with Diane, because that's really important information in this case. Parties could be encouraged to consider alternative pathways in parallel to making a complaint. So they might involve other family or friends or service providers like advocacy agencies like yourselves to ascertain whether there are alternative means to address the concerns in a less intrusive manner. Because of course, once an investigation commences, there are risks to the relationship because of that formal action being taken. So, sometimes it's better to have a look at alternatives before you go down this path. If there's readily available information around the concerns and capacity, it could be explored whether other parties have the ability to submit an application to QCAT directly, and we could provide some education around the role of a formally appointed guardian or administrator. And of course, if she does retain capacity, we would be strongly encouraging her to enact an enduring power of attorney for another appropriate person, and making sure she does have somebody who can step in and help her out when that necessity arises.
Excellent. That's some really comprehensive answer and great practical steps there. Mary Humphrey, if I could bring you back in again, there seems to be many steps along Beverly's journey where decision making was taken out of her hands, respite care, moving back to her ex-husband, house occupied by a daughter. And whilst, you know, there could be a gloss of helpfulness cast over that on the surface, with the benefit of hindsight, what steps could have been taken here?
Okay, so we get to, from my perspective, I'm having a look at Beverly's locus of control, and here she has been living a life for 15 years, controlling to a certain extent, deferring part of her life, but largely managing that herself. And then she's in a situation where someone else has taken over and there's abuse identified by a service provider. I think if that service provider had taken a different approach, where instead of trying to take over and tell or point Beverly in the right direction, work with Beverly to see what opportunity there was to help her feel more empowered in her situation. John mentioned advocacy, but even before that, you know, Beverly had indicated that she felt a bit overwhelmed by the system, that she didn't understand Centrelink, that My Aged Care was a baffle to her. So at a very fundamental level, there was an opportunity to help her feel a little bit more in control by pointing her in the right direction to get some support there, and also in regards to the police being the option, advocacy perhaps was a gentle way of helping her to get that support where she could process in a safer way the situation that she was being put into before it got to the place where she was taken to respite. So I think right back where that service provider was involved was the opportunity to increase Beverly's agency and control in that situation.
Yeah, that's a very helpful point, and you know, a pivot point for Beverly, who could have been given the opportunity to take on information at a pace that would help her. Dr. Khatib, Beverly experiences in aged care what could be classified as chemical restraint, and what other options would the facility GP, who did know Beverly very well at that time, having probably just met her, have at his disposal or her disposal?
Yes. Karen, in the audience, this case again bring two things home, which I will refer to first before answering your question. One is that dementia and capacity are two different things. Reading through the case, Beverly has reported memory problems. She got confused. Somehow she ended up in a nursing home, and that too in a dementia secure unit, whereas I don't think a formal dementia has been diagnosed. But then there is a comment that she did not want to give her EPOA to her daughter, which means she had some sort of capacity. So the point I want to bring home is that dementia and capacity are two different things. You can have capacity with dementia. You can lose capacity and not have dementia. So it's not as simple as if they've got dementia, let us assume that they've got capacity. The other thing is that restraints are generally used for challenging behaviors or difficult behaviors in dementia or psychiatric conditions. The point I want to make here before I answer your question is that behavior is an end product. It's a result of a number of factors as we go through Beverly's case: deprivation, abuse, influence, hospital admission, nursing home, change of environment, and then in a dementia secure unit where surely there are other violent people with very advanced dementia. So to answer your question now, remember, and we should all remind ourselves that restraint is the last resort in medical care. To us specialists, it's not the first, so you don't reach for your syringe or your prescription pad first. it is actually the last resort. So you ask an important question. There are a number of things available to be thought of before restraints are ordered. And there are a number of restraints. Chemical is one of them. There's physical and environmental and seclusion and so on. In hospitals, they now have special one-to-one. So they put the person there and there's a person outside just watching you. Before thinking of chemical restraints, of course, non-pharmacological measures have to be adopted, making the patient safe, making them understood, screening for any treatable factors. Do they have a urine tract infection? Are they in painful fecal loading, constipation, and so on? There are a number of treatable triggers that could be leading to abnormal behavior. Is there a risk of harm? Is there already a risk of fall before you introduce them to chemical restraint, which may increase that risk? And once you've exhausted all of that, once you've gone to the non-pharmacological measures, taken as much help as you can, try to quickly sort out if there are any treatable factors that you might want to address. When you do think of chemical restraint, the golden rule which we follow in geriatrics and psychogeriatrics is start low and go slow. A minimalist approach, keeping in mind that you've got to monitor, have an entry strategy so you can start a chemical restraint, but remember there must be an exit strategy, not that we confine them to that and forget about it, and months later they're sort of, as the patients use the term, my mother became a zombie. Well, a zombie has to be dead first, but anyway, perhaps they mean that they're motionless or expressionless or something like that. So, number of factors to be thought of before one goes to chemical restraint, and the health reforms and the aged care bodies are very, very cautious about it. Right until 2021, you have to now document what you're doing, reasons for it, and so on.
Thank you, Doctor. And then secondly, there's, although Bevel acknowledges some memory issues and concerns, there's not been a formal capacity assessment made so far, and you thought her refusal to do an EPOA was indicative of a level of capacity and agency. Are there indicators in Beverly's situation that you think warrants a formal assessment? And what sort of assessment would you consider if you were referred by the GP?
Yeah, for sure. I would approach it in a manner that she does need an assessment, and I often tell my registrars in training and so on that you need a diagnosis first. When I get referred a person for a capacity assessment by a solicitor, certainly there's a health condition involved. There's most likely a dementia or a mood disorder or influence of something which they want me to comment on. So I often make a point that has a diagnosis of dementia been made, have some steps been taken to rule out that she doesn't have a space occupying lesion or a stroke and so on. So that's a preliminary workup that I'd like to get done, if not done already. Once that is done, of course, she would, and suppose none of those factors are contributing, or even if they are, and we come to a conclusion that her capacity needs to be assessed. So it is a legal process. A diagnosis of dementia, I often get, could you give us a letter saying she has no capacity? And I say, no, I've got to assess capacity. You follow a certain process. In her case, I think the basics, the lifestyle decisions, healthcare decisions, financial decision making, I think those need to be assessed because she has lost a lot and ended up in a dementia secure unit, now on chemical restraint. So one would certainly want to know what her capacity is, whether she has it or not, and for what aspects.
Thank you, Doctor.
Does that answer your question?
Yeah, that's very helpful. John, there's some outstanding legal issues, surrounding Dr. Khatib's responses there. And oh no, before I ask you that, there's about consent to restrictive practice in Queensland. What's the state of the legal framework here?
So the answer to that is complex, unfortunately. I'll give some practical advice in a moment, but the answer is complex. So Beverly's been placed in a secure dementia unit from which she presumably can't leave. That's a restrictive practice, an environmental restraint. Her freedom to move is restricted. She's also been prescribed risperidone, which in her situation amounts to a chemical restraint. Would be termed a medication if it were being prescribed for a kind of therapeutic benefit, but here it's clearly to manage her behaviour. So under the current
Thanks, John. And whilst you involved here, there's some outstanding legal issues, and one we've got no formal decision maker in place relating to accommodation, and some question marks over her capacity. Is there any impediments to legal help, or how can Beverly access legal help?
Yeah, so I'd be suggesting here that at the outset, Beverly seek advocacy assistance. This will be able to ascertain whether Beverly, with support if necessary, can make decisions about her own future. If she's clear that she wants to be in her home without her daughter or grandson, then the question becomes one of implementing this. She could, at one extreme, seek police assistance to evict her daughter and grandson. Hopefully it wouldn't come to that. Instead, an advocate can help her to ensure that she's able to convey her desire to her daughter and grandson. If nothing happens, then police assistance may be required. Another option, as we say, is the appointment of a guardian who could determine where Beverly lives in the event that Beverly's not able to make a decision about this. And I know the next discussion will turn to that point. A less restrictive option is certainly better, if that's at all possible.
Excellent. Thanks, John. Yeah, we'll turn to Lisa Pritchard now. This case, as John sort of hinted at, may involve QCAT at some point. What sort of involvement does the Public Guardian's Office, when matters such as Beverly's come to QCAT, is there any involvement at the pre-hearing stage or hearing stage?
Yeah, thanks, Karen. And just noting John's comments firstly about appointment of guardians potentially for restrictive practice matters. That's still a question of jurisdiction to be settled. So I'll set that part aside and deal with if guardianship's involved around the legal matters that are potentially facing Beverly. So our pre-advocacy team is made aware of every hearing in Queensland before QCAT, so we get to see what's going before QCAT. But the team only becomes involved in matters where OPG or where a guardian is proposed for the first time, or where we were previously appointed for a person, or where a tribunal member directly requests the attendance of one of the team in a hearing that they're presiding over. So this can occur when a matter has multiple applicants in high conflict, for example, or there's some complexity in the circumstances and the decision making that's going to be required. So in the case of Beverly, if an application was made by her son to appoint himself only, OPG wouldn't become involved unless directly requested by the member.
Mm-hmm.
If the service provider or any other party made an application and they proposed public guardian be appointed as the decision maker, then the pre-advocacy team would receive a notice of hearing, and we would have a look at the QCAT file, we'd review the application and the supporting documents that are submitted to QCAT. The team might provide written submissions only, or if required, a member of the team will actually attend the hearing to assist the member. Given the involvement of likely undue influence and the unstable family dynamics in this scenario, it's likely the pre-advocacy team would attend the hearing. So when they attend, they'll provide information and education about the role and function of public guardian. They'll ask questions relevant to the circumstances and decisions required to bring to light any other considerations that need to be aired during the hearing, just to make sure any outcomes are fully informed. The pre-advocacy team might contact applicants to seek some further clarifying information and to provide information about advocacy services that are available to support them during the hearing process. And we might also make a direct recommendation to the tribunal that a separate representative be appointed for Beverley under Section 125 of the Guardianship and Administration Act. And that's to ensure that her views, wishes and interests are represented, and that her rights, interests and opportunities are promoted and safeguarded during that hearing process. So in Beverley's matters, it's likely OPG would advise her son and her daughter, if she applied, to source an advocate to assist them in the hearing space, and we'd likely refer Beverley to an organisation such as ADA to provide support during the QCAT process. So making the referral prior to the hearing allows the matter to proceed on the day without as many complications or further delays and rescheduling. And there's also the option on the day of the hearing for the member to consider appointing the advocate for Beverley, who has already met with her, built rapport with her, gained her views. There's an opportunity for that person to be appointed as a second representative for the duration of the hearing. So just importantly to note that we can't make representations around financial matters in a hearing, but the pre-advocacy team would highlight any financial risks relevant to the decisions that are required.
Excellent, excellent. Well, I might stop you there, Lisa, because I'm realising we're now pushed for time, and bring Nick in, and assuming that the point where Beverly's at her ex-husband's house, how might the police get involved, and who could raise a complaint if Beverly's reluctant?
So, Karen, we can apply for an order under these circumstances, as Beverly and Diane's is a family relationship, regardless, taking outside the carer factor. We can launch an investigation, support worker, friends or family, or any of the other agencies that have spoken today, including the Elder Abuse Prevention Unit. The ability to assist her returning to her house, given the distance, obviously we would have to try and engage some support agencies to assist in transport, and we could also ensure that police presence was available at her home when she arrived there to ensure that no offences took place. That's regardless of whether or not there was an order in place. That is something that that police do on a regular basis under the ambit of keeping the peace generally.
Excellent. Thanks, Nick. And just to bring Rebecca back for this case study, looking at these two case studies, are there any, do you see any areas that a complaint may have been brought to the Queensland Human Rights Commission?
Thanks, Karen. I think my short answer is not really. Nothing jumps out at me. So just in relation to that, I do want to make a few brief points that might help people to understand our complaints process. So the Human Rights Commission is does receive complaints both under the Human Rights Act and the Anti-Discrimination Act, but I'm just going to focus on the human rights aspect of our complaints function. Firstly, the Commission only accepts complaints against public entities. So you have to find a public entity who's breached their duties under human rights. So people like Frank, Diane and Simon, they're all private players. They're not going to be captured by the Human Rights Act. The GP who prescribed the risperidone is probably not going to be a public entity because they're funded through Medicare. I mean, there are some aged care facilities across Queensland that are run through hospital and health services, so they might be public entities that have responsibilities under the Human Rights Act, but you know, a large number of private facilities that are not don't have obligations under the Queensland Human Rights Act. Commonwealth entities are not going to be captured by the Human Rights Act. So, I mean, just to have an artificial example, if, for example, Carmelita needs really proactive follow-up to ensure that she gets the surgery that she needs, potentially if the hospital doesn't make those adjustments and doesn't do the follow-up that she needs in order to access the health services, then potentially there's a breach of human rights in relation to access to health services without discrimination. The second quick point that I wanted to make is that in order to bring a complaint under the Human Rights Act, you need to make an internal complaint first to the public entity. There's got to be a genuine attempt by the complainant to try and sort the issue out at an early stage. And you know, I'd like to be quite positive about that requirement in the sense that there have been a lot of great outcomes achieved at this early stage to get early intervention into a potential human rights, an allegation of a human rights breach. So that needs to happen at first instance before the Human Rights Commission will accept a complaint. And then finally, thinking about, well, what does the Commission actually do when it receives a complaint? And we're a dispute resolution service, so we offer conciliation services. The resolution of the complaint is through agreement. We don't have any compulsion powers. We can't enforce our decisions. And we don't make any findings of fact. So it's about bringing parties together and trying to achieve an agreement through resolution. If there is a more appropriate way to deal with the complaint, so for example, there's guardianship through these examples, the more appropriate course of action would, of course, to go back to QCAT and have that order removed or reviewed at least. And there are, you know, there's authority through QCAT to do that. And you can raise human rights at those QCAT proceedings. There's going to be a more appropriate process there. Thanks, Karen.
Thanks, Rebecca, and thanks for the tip about raising human rights at QCAT proceedings. And I note there was a question about Section 125, the benefits of that appointment of a separate representative, and that's often a role that falls to the representative as well to raise those concerns. We're down to the last couple of minutes, and I just want to note that the audience have raised undue influence as 50% of the main key theme, sense of agency, empowerment 22%, capacity and consent 13%, and human rights 15%. So it's good that there's a mixed picture. And there was another question about use of capacity assessment guidelines in practice, which I'm not sure if anyone's able to answer that quickly. Maybe Mary, do you see much evidence in Queensland Health of utilisation of the capacity assessment guidelines?
Not at this stage.
No, they're a great piece of work, and I encourage
everyone. They are
everyone.
a great piece of work. I think, I guess, the issue is that when capacity assessments are presented with an application, there's no requirements to have accessed that that document in making that. And I guess if they were to go hand in hand, there might be more uptake and utilisation of that document.
Okay, so thanks, Mary. In the time left, I just want to quickly go around the panel, probably starting with you, Mary. What are the top thing, probably with the time we've got left, top thing that you think the audience would be good to take away from the two presentations today?
Look, I think it is really important that we do focus on the issue of ageism. I think working in health, I know it is a big issue in regards to stereotypes and just age differentiation in how a person is perceived. And that has a really big impact on how they're treated, particularly if they end up in a situation where they are deemed not to have capacity. And flowing on from that, I also think that the connection between that sense of agency and empowerment that goes hand in hand with having a good sense of who you are, and that you can have some control in your situation. So rather than people doing things to you, that you are part of whatever happens.
Thanks, Mary. And Rebecca, your key takeaway.
Sorry, just had to unmute myself. Look, I think whether or not the Human Rights Act applies, I think it provides a really solid framework for understanding the issues that might be raised for a person in a person-centric way. So really focusing on the individual's rights and understanding what the issues are arising from that.
Thank you. And Lisa Pritchard.
Thanks, Karen. I would say we know from the EAPU's recently released year in review that elder abuse, some of the key barriers to changing the abusive situations are the victim's individual vulnerabilities, their fear of further harm, concerns about protecting the perpetrator and their relationship. So those barriers need to be considered and minimised by services that are supporting victims. And it really highlights the importance of different organisations and services working together to address and change that situation.
Thank you, Lisa. And Dr. Khatib, what are your key takeaways?
Yes, the key takeaways are that certainly these are multi-domain issues, and I'm very encouraged to see so much support and advice available. I've learned a lot from this being on the panel. I'm sure the audience must have. These are truly, both of these cases were truly medical legal cases. So there's medical involvement, there's a lot of legal social agencies, and there's a lot of elder abuse. There's unnoticed, bypassed, not reported elder abuse, and I'm pleased to know that we have so much support. And of course, as you all might have felt, the underlying flame in all these cases is cognitive impairment, capacity, abuse. So a medical diagnosis, a medical assessment is one of the important aspects and as a team we deal with these all together.
Thank you, Doctor. And Nick, what do you see as the key takeaway for our audience from your perspective?
Key takeaway is that collaboration is the key. There's a lot of good people in the sector working towards one key target, if you like, or aim, which is to keep older people safe. We all have a part to play, and in light of this year's WEAD theme, let's ask the question. Don't just sit back and do nothing.
Thank you, Nick, and thank you, and remind all our audience as well to really embrace the multitude of WEAD activities that are available to us this week and tomorrow in particular. And John,
Thanks,
last but not
Karen.
least.
Yes, just quickly, in addition to needing to take appropriate action in response to any abuse that's witnessed, we must start with what the person wants to happen, enable them to express what they want to happen without there being undue influence on them at that stage. And also, if we're coming in to assist a person, we need to come in with knowledge about what support services are available, so we don't put people in invidious situations where they think they have to put up with abuse in order for instance, to be fed. So we want to know what the person wants, and we need to come in with support options. Thanks, Karen.
That's right. Very, very, very good key takeaways from all our audience. I really want to thank the panel for their presentation and the preparation for the presentation. Unfortunately, Lisa Rackmuth wasn't able to extend her presence this morning, but I definitely want to thank Lisa for her overview and for her emphases today. And also some of the questions were around, how do we lobby or campaign for better elder abuse or elder justice frameworks, which is a phrase that I like from Lisa, and it sort of falls on all of our shoulders a bit to keep pushing that barrow forward so that we have a good system for older people to be able to rely on. So thank you to the panel, and thank you to the audience and those listening by recordings. Thank you very much.